And then I realized she's right. Maybe we've become not impervious as such, we've become used to these things being done. You know, when they are not right, we should actually uphold the right things. Even if lawyers will not like you, for me, I don't think that matters much, but we have to do the right thing and ensure that the right thing is done at all times. And if we do not, stop it, it is going to continue and it will become part of the culture. So when someone is quiet, then it will be like something is wrong. There must be a little bit of noise, a little bit of chit-chatting and whatnot. So I think that is a very legitimate concern. I'm also going to resolve to nip it in the bud. But just for information, I've been speaking to the Chief Registrar, and she'll be bringing copies of the Judicial Code of Ethics. That will be for you to read. And because most of the things that I spoke about, you know, they are contained in it. Maybe what we can do is over the lunch hour, you can just read it so that if there are any issues that arise, particularly from our code, that we may maybe deal with them briefly. Now, what I want to do is to proceed. The next topic is the one that deals with non-compliance with the rules of court. I just want to get the actual topic is, non-compliance with rules of court. That is part 6. Let me turn to part 6 now. I hope you all have copies of the rules of the High Court. I normally say in my court, when I ask questions of lawyers and they do not have their rules of court, I tell them that when you go to church, you carry the Bible. When you go to the mosque, you carry the Quran. Unless you know the verses by heart, then you are okay. Okay, part 6 of the rules is entitled Non-Compliance with the Rules of Court, Practice Directions or Court Orders. So this part deals with the sanctions that may be employed by the courts on errant parties and or their legal practitioners. So what I want to start with is maybe to paint the picture before the new rules came into force, before the advent of judicial case management and what judicial case management has done. And it is from that perspective that we are going to look at at non-compliance. I think that the uniform rules of court, they used to apply in Namibia. Is that correct? The uniform rules of court, the ones that applied in South Africa, they were the same with those that applied in Namibia before judicial case management. And I think they were generally the same even in Swaziland, although there were variations here and there. But what used to happen, for instance, is that if you issue a summons against a party, okay, there used to be a simple summons and a combined summons. Let's talk about the combined summons. If you issue a combined summons against a party, then the rules would say that party has a right to file a notice to defend within a certain period. And then it would also say when the plea is supposed to be filed. And then when replication is supposed to be filed. And then there would then be rules relating to discovery and everything. So what judicial case management has done is that it has given the powers to move proceedings to the hands of the court away from the parties. Instead of the rules saying such a document must be filed within such and such a period of time, it is now on the judicial officer to call the parties in and tell them, you file on such and such a day, you file on such and such a day. And then the result of the litigation which was party-driven was that if a party did not comply with maybe the time limits that are imposed by the rules, you then had to go to court to seek an order to compel them. And that would be an application of its own. And once that is done, that party is compelled and then has to file. So which was a waste of time and costs. So what I want to submit to you is that the success of judicial case management rests very much in the court being in charge of the proceedings. And then the problem with the previous regime was that there were no readily available sanctions for the court to impose as and when there was non-compliance. But now if you do not comply, the court can crack the whip readily without any application having to be made by anyone. Now, when we speak about a court order, it is the authoritative binding voice of the court, and the rules of court in that regard become the backbone of the application of, they're the backbone upon which, justice is attained, and they also establish some uniformity in what has to be done and when. When we speak about compliance, there are many stages that we deal with when it comes to judicial case management. We start at case planning stage. And then from there we move to case management stage. And then from there we move to pre-trial stage. So at all these various stages, there are certain steps that need to be done, and the court issues orders at every turn. So here it is not just with compliance with the court orders and the rules, but there are also practice directives which direct on some specific issues as to when those should be done. Unlike maybe with other forms of adjudication, when it comes to judicial case management, as I've mentioned, in this particular era, the court can crack the whip as and when it becomes necessary without waiting for other parties to approach the court. Because when the court cracks the whip, then you would expect that cases are going to move forward and people will be on notice that if I do not comply with the rules of court, there's going to be a sanction. We will deal with the various sanctions that are provided for in the rules. So we all know what the consequences of disobedience of court orders is. Because in terms of the old rules, there were no sanctions. As I said, you had to apply to court. So and so has not filed their plea. So you had to go to court in order to get an order telling them to comply and by when. But now, as I say, once a summons is filed, the parties file what is called a joint case plan. In the joint case plan, they set out the time limits which they ask the court to endorse for the filing of the respective sets of papers. And also to identify issues that might come up. It might be that there is an issue of an irregular step. It might be that there is a special plea that needs to be raised. It might be that there is an exception. All those things. So what the parties do in the joint case plan is to then say there is an exception that we want to raise, and then the court will then give directions as to how the exception must be dealt with. And in that regard, the court will say, okay, this is an exception. There is a very important rule, which is Rule 32, Sub-Rule 9, and Sub-Rule 10. This makes it mandatory for all parties where there are interlocutory proceedings that arise during the course of a case to resolve or to attempt to resolve those matters amicably. For instance, if it's an exception, and the basis is that the particulars of claim are vague and embarrassing, then the parties will need to sit down. We are saying that your summons are vague and embarrassing because of A, B, C, and D. And you might find that you agree that, I think this thing we overlooked, and then you then agree, you file your amended, or your notice to amend by such and such a day. If there is no objection to the amendment, then the matter proceeds. So where that rule is not complied with, that is Rule 32, 9, and 10, there is a judgment of Mr. Justice Parker of Apollos versus Mukata, which says that where parties do not resort to Rule 32, 9, and 10, then that matter must be struck from the roll for non-compliance with Rule 32, 9, and 10. Because one of the overriding principles of judicial case management is to try and save costs and to deal with matters on their merits. So, which is why it is a very, very integral part. So what I was saying is that depending if there's an exception or some other issue that arises, that is when you then have to resort to Rule 32, 9, and 10. And one thing I can also say about Rule 32 is that it also sets a ceiling for costs. They do not go beyond 20,000. And I think that is Rule 32, Sub-Rule 11. And why this was included, I think it was to ensure that, because you might find that you are maybe dealing with a multinational corporation, and you are an individual. And so what happens is that you sue that corporation, and sometimes they kick you out of court by persistently bringing matters and you being involved in costs. Thank you. Yeah, so what I was saying is that Rule 32.11 sets a ceiling for all cases in interlocutory matters not to be more than 20,000. And this is to make sure that people are not kicked out of court because they no longer have the financial muscle, so to speak, to be able to proceed with the litigation. Now, then when we come to case planning, let's say the matter does not have intricacies like exceptions and everything. So what will happen is that the parties will say, I will file my plea on such and such a day. The plaintiff will file his replication, or if there's a counterclaim, plea and counterclaim must be filed on such a day. The replication and the plea to the counterclaim must be filed on such and such a day. And then the replication to the claim, to the plea, to the claim in reconvention must be filed on such and such a day. So those become firm court orders. Once the court endorses the case plan, it then becomes an order of court. And where a party does not comply, for instance, if you have not filed your plea, you do not have to make an application to court to say so-and-so has not filed, and then they must be called to come and explain. No. Once that has been done, the rules give a mechanism for instantly dealing with that non-compliance. And that is how the matters are to be moved forward. And the same applies when we go to the next stages, case management, or when we come to pre-trial. So maybe let's just look at some of the provisions. Are there any questions so far? That's right. And I think this will tie in with maybe when you come to deal with Rule 132, because there are certain instances where you find that both parties have neglected dealing with the matter, and then the matter then comes in the hands of the court, and the court must do something to ensure that the matter is either dealt with and finalized or removed from the roll. Okay, Rule 53.1 provides as follows. If a party or his or her legal practitioner, if represented without reasonable explanation, fails to attend a case planning conference, a case management conference, a status hearing, an additional case management conference, or a pretrial conference, or to participate in the creation of a case plan, a joint case management report, or the party's proposed pretrial order, and the issues are listed. It then says the managing judge may enter an order that is just and fair in the matter including any of the orders set out in sub-rule 2. So here it means it's an omnibus sort of provision where you don't do anything. They do not want to, you might not be cooperating with the other party, because in some instances, in fact, when it comes to the joint case plan, if the parties do not file a joint case plan, the court has a right to then issue an order to say, on such and such a day, the plea must be filed, the replication must be filed, discovery must be made on such and such a day. So the fact that the parties have decided that once they are called by the court for a case planning conference, and then they come, they haven't done anything, the court can grant a default order, putting them to terms to file on specified dates. So we are not always waiting for the parties to take the initiative. Where they do not, the court will then move forward and ensure that the matter proceeds, because there are the benchmarks that need to be followed in relation to the turnaround period of cases that have been, that have been lodged. And then when we look at part 6 of the rules, particularly those dealing with sanctions, one of the things that we must do is to create a nexus between this rule and what in fact, if you look at Rule 1, Sub-Rule 3, Rule 1, Sub-Rule 3, it speaks about the overriding objectives of judicial case management. And this is how it reads. The overriding objective of these rules is to facilitate the resolution of the real issues in dispute justly and speedily, efficiently, and cost-effectively. And then in the context of the sanctions rules, we are dealing here with efficiency, with speediness, that there must be no unnecessary delays in the conduct of litigation. And in many instances, you'll find that the party with a weak case is the one who dragged their feet. So the court will crack the whip on their feet in order for the feet to move in tandem with what is required by the rules. So if you read Rule 3D, for instance, Rule 1, Sub-Rule 3D, ensuring that cases are dealt with expeditiously and fairly, and also recognizing that judicial time and resources are limited, and therefore allotting to each cause an appropriate share of the court's time and resources, while at the same time taking into account the need to allot resources to other causes. And then I think those are the main issues that I want to touch upon. I hope you are getting, I'm trying to connect the overriding objectives of judicial case management to the sanctions regime that is provided in Rule 53 or in Part 6 of the rules. In this connection, I will be going back and forth. If you can maybe turn to Rule 17. It's like we're in church today. We're turning the pages of the Bible or the Quran, as the case may be. This is what Rule 17, Sub-Rule 2 says. Under these rules, the control and management of cases filed at the court is the primary responsibility of the court. The parties and their legal practitioners must cooperate with the court to achieve the overriding objective. No, I didn't read it well. I didn't put the emphasis where it should be. Under these rules, the control and management of cases filed at the court is the primary responsibility of the court. You can as well put a full stop and then cancel the end and say the parties and their legal practitioners must cooperate with the court to achieve the overriding objective. So it puts the court at the center. The court must be the driving force. And as a result, the court must then crack the whip where the parties or their legal representative slack in carrying out functions or responsibilities or complying with court orders that have already been issued in order to ensure that the matters are dealt with speedily, efficiently, and cost effectively. And then in this regard, it is not just the court. Although the primary responsibility rests with the court, there is also some role that the legal practitioners need to play. And these are set out in Rule 19. Rule 19 deals with the obligations of parties and legal practitioners in relation to judicial case management. And then it reads, for instance, every party to proceedings before the court, and if represented, his or her legal practitioner is obliged, A, to cooperate with the court and the managing judge to achieve the overriding objective, B, to assist the court in curtailing proceedings, C, to limit interlocutory proceedings to what is strictly necessary in order to achieve a fair and expeditious disposal of a cause or matter, D, and this one applies directly to what we are dealing with, to comply with any order or direction given by the court at any stage of the proceedings. And then D, to attend all case management conferences, status and informal hearings arranged by the court. F, to comply with deadlines provided for the taking of any steps under these rules, the practice directions, and any applicable law with diligence and promptitude. E or G, to use reasonable endeavors to resolve a dispute by agreement between the persons. I think these ones I'm not going to. And then maybe I, to act promptly and minimize delay. So I think when you look at the rules, you can see the tapestry that from the overriding principles of judicial case management as found in Rule 1, Sub-Rule 3, then you come to Rule 19, which sets out the obligations of the parties, and then you move to then Rule 53, which says what happens if the parties or their legal practitioners do not carry out what is expected of them, particularly maybe those issues that are pointed out specifically in Rule 19. What happens to them? And what I must mention is that when you read Rule 19D, it says that every party to the proceedings before the court, and if represented by his or legal practitioner, is obliged, D, to comply with any order or direction given by the court at any stage of the proceedings. It is couched in peremptory terms, which means that when there is non-compliance, then there is a whip or there is a consequence in doing so. And then people may then argue, no, but I don't agree with the order. I do not agree with, that does not matter. Once a court order is issued, you comply with it. I'm told that the police say comply and complain later. There is actually a Zimbabwean case on the doctrine of clean hands. I think the Supreme Court in Namibia did not agree with it, and I didn't agree with it either. I think it was to do with the closure of newspapers. And they were complaining that closure was unconstitutional. And the Supreme Court of Zimbabwe said, no, you must first comply. And then the court said, no, not in this case. If something is unconstitutional, you have to deal with the constitutionality. You cannot say to go and comply with something that is unconstitutional, and then later we shall see whether you are supposed to comply or not. But that's a totally different matter altogether. But in this particular case, once a court order is issued, a party has to comply with it. If not, then there must be some explanation, because what we saw is that in Rule 53, the words used are without reasonable cause, fail to, which means there are some instances where a party may be unable, for whatever reason, not to comply. But once that happens, the onus is on that party to approach the court to seek condonation or to seek extension of time or whatever it is in order to be able to comply. Is that clear? Yes. So, what this rule does is that it is not draconian. It does maybe take into account that there may be reasons why a party, so which means it doesn't just say you've not complied and then the sanction is, is then issued without giving you any hearing. But as I say, the onus must be on the party in default to approach the court promptly and to seek an extension of time or condonation for non-compliance with the order of court. Well, I think one of the things that we cannot run away from, and I think it is an issue that is being addressed, is the number of judges that we have at the High Court. And I think the Judicial Services Commission is acutely aware of the numbers. I think the work is just growing exponentially. And one of the things that I observed is that depending on how things work out, you might have a group of 2 separate judges. You might have those who are very strong on judicial case management, but you'll find that going to court, sitting, listening to cases and delivering judgments may be a challenge. And then there's also vice versa. So that in other jurisdictions, what I'm informed is that they've got 2 groups of judges, those who just deal with managing the cases, getting them to the point of where they are ready for trial or hearing. And then those others take the cases from there. So where you are still combining the 2 with the number of matters that are coming in, it becomes a challenge, because one of the things that we're informed was that judicial case management slots must be either or late afternoon. This is such that, it was done such that it does not interfere with the ordinary running of the court, so that trials can go on. So that's why it's either early in the morning or late afternoon. But now with the volume of matters that are coming, you find yourself having so many matters that it is humanly impossible for you to deal with all the matters that come within the guidelines set, on the Tuesday. I've had instances where I'm informed lawyers sit from 8:30 to 8:30, 8:30 a.m. to 8:30 p.m. with no break throughout, because of the volume of matters that come in. So I think this is a matter that will need to be, carefully managed, so that as much as we comply with the rules, other considerations that come into the picture are also taken care of. Because I think with the matters that are coming in, you might find that, let me speak about my own role. My case management role presently is on Wednesdays. So what happens is that on Mondays, I start my week. Normally, I'm in trial. Monday to Friday, that's my life. I'm in trial court. The fact that I've got case management, on Wednesday, I work until maybe noon or 12:30 in order to prepare for case management in the afternoon. And normally that is for the paper files. But for these other files, you start working on the weekend. On the weekend, you start reading in preparation, making your notes. Then you come to case management on Wednesday, you do your case management. And in the middle of this, you are doing your trials, you are doing your interlocutories. And then also there is a second motion or urgent, whatever it is. These things go along together. And then at the end, on Thursday, maybe I'm still in trial. Friday, I'm in trial. On the weekend, I must sit and do the orders for the case management, because if you carry them on to the following week, you'll be in trouble. By Tuesday, you already are preparing for the coming case management. And then also, in addition to this, we get cases for second motion. Even if you are not doing second motion, you always get default judgments. There may be 7, sometimes 16, which you need to deal with. You go through, grant orders, or refuse, as the case may be. And then we also have matrimonial cases, which we also have to do, which are apportioned amongst the judges. So it's a lot of work. And then it makes it very difficult in some instances, particularly because of the volume of work, to be able to stick strictly to the guidelines regarding when things ought to be done. But then the other thing, which we must not lose sight of, is that it does need the judges to be very harsh in some instances on litigants. Because some litigants just want to waste time. Them and their lawyers. No, we're negotiating. And a whole month, 2 months, 3 months pass by, and they're saying, no, we are just about to reach settlement. And then the matter just keeps going on, and it's not complying with the practice directive. So there is as much as you do want to encourage parties to negotiate and deal with matters, but there must also be a cutoff point, because they might use that in order to buy time and see what they can do. And then you find that after a lengthy period, the matter is not settled. And you are way, way out of line in terms of compliance with the turnaround periods of maybe closure of pleadings and these other issues, mediation and so forth. I hope I'm answering your question, ma'am. Okay. So, now coming to what is the whip that is at the disposal of the court where parties have failed to comply with court orders or practice directives. The court gives, the rules give the court a latitude of different measures that it can employ. One is to refuse to allow the non-compliant party to support or oppose any claims or defenses. Striking out pleadings or part thereof, including any defense, exception, or special plea. Dismissing a claim or entering a final judgment. Or D, directing the non-compliant party or his or her legal practitioner to pay the opposing party's costs caused by the non-compliance. So here there is what I can call a buffet of options that is open to the court to grant in appropriate cases. So which means then what happens is that in terms of Rule 53(1), if a party does not without reasonable cause, which means what the court has to do is then to bring to the party its non-compliance. And the party has to file an affidavit explaining its non-compliance. Sometimes the party will, of its own motion, suo motu or mero motu, whichever one you choose, decide to bring an application for condonation to say, I did not file my plea on such and such a day, and then they bring an application to court for the court to consider. And if the court grants the application for condonation, then it will give directions as to how the matter proceeds. But if the court does not grant the application for condonation, it will issue an appropriate order, particularly in terms of Rule 53, Sub-Rule 2. And if you look at the possible orders that may be issued, some of them are very drastic indeed, very drastic. You can strike out a defense, strike out a claim, strike out pleadings, dismiss a claim and enter final judgment, or cause a party or its legal practitioner to pay the costs. There is one case that I dealt with. What is it called? It's Okahao Town Council versus Campbell, N.O. I think what happened in that case is that the plaintiff, who was the one who initiated the proceedings, applied for condonation for non-compliance with a court order. And then the court put them to terms that they must file the application by a certain period, which they did not do. And then the matter came on a number of times and was postponed at their instance. And then when they eventually, the application for condonation was heard, the court found that the reasons for the non-compliance were not satisfactory. And the claim was, I think the claim was refused. And eventually I think the matter settled. So one of the things that is important is that parties who do not comply must with promptitude approach the court to seek relief. I think there is another case that I dealt with. It's called, it's IA Bell. I can't remember what the other side, but I will find it and make it available. So what happened in that case is that the plaintiff issued a summons and the defendant was put to terms to file a plea. They did not until 3 months later. And then when they applied for condonation, the reason given was that the lawyer said I was very busy. It was over the Christmas period. My secretary was away. I had to type the pleadings myself. That was the reasoning. But let me see what the court said. I hope I can be able to find this quickly. But the courts quoted, there's a man called Cicero. Cicero was apparently a very, very busy lawyer. And he wrote, and he said, if I can write a letter to my brother, then I have got 2 minutes. If my secretary does it, then I have no time. What he was literally saying is that a lawyer's life is a busy life. So you are busy, and if you are too busy, give the work to others. Do not take work that you cannot be able to do. And I think that is the lesson that was learned. Let me just see if I can find. The other one that I spoke about is Okahau Town Council versus Campbell. It's 3519 of 2015. 3519/2015. And then it's 2017, square brackets, Namibian High Court Main Division 160. And it was delivered on 9 June 2017. What's happening here? Okay, when it comes to contempt of court, civil contempt, there are two things, although I did not prepare for this one. There are two types of orders. There are those called orders ad prastandam, and there are those orders called orders pecuniam solvendam, I think. Ad solvendam. Let me just check. I don't know, but I think it's somewhere in the paper. Yes, there are orders. Okay, what happens is that there are two types of orders that courts issue. There are orders which call upon persons to do or not to do certain things. I think those ones are ad prastandam. And then when it comes to orders ad pecuniam solvendam, I think it is, I hope I'm putting, that is in relation to payment of money. And the order is that where it is an order ad prastandam, non-compliance with that order may result in civil contempt. If a party is ordered to remove a cause of nuisance, for instance, that is an order which calls upon the party to do a particular thing. or maybe if it's an order ordering the party to refrain from doing, maybe being a nuisance, that is an order ad prestendum. And then if that party does not comply, I think there are three elements that you need to show. That the order was issued, that it came to the attention of that person, and that they willfully disobeyed the court order. I'm just talking from headache, but I hope I'm correct in that regard. And then in that regard, the court will grant the order. But when it comes to orders for payment of money, those orders are not issued. I mean, you cannot hold someone in contempt, because what happens is that in those types of orders, there are execution processes that are in place. So once the court says you are liable to pay $1 million and the person does not pay, you cannot then take them to court that, oh, so-and-so refused, therefore he must, okay, because there used to be what was called civil imprisonment previously, where people who did not pay, they were confined to prison, the court would make an order, you'll be imprisoned for such and such a time. But as time went on, it was found that that was not the right way to deal with these issues. So that there are now execution processes. If the person owes $1 million Namibian dollars, then you have to issue a writ of execution. The sheriff goes to the home of the person and they attach all the movable property. They ascertain the value and maybe they sell those. And then if there's still some amount owing, then they go for the movable property, and then eventually if there's a house, then it is sold. So I think this is where you draw the distinction. You cannot take someone to court or even in prison for failing to comply with an order in relation to payment of money. In fact, there's a case that I had actually issued an order. The lawyers came to my chambers a few weeks ago. It was a matter in which the government had to pay, I think it was about 500,000 Namibian dollars. It was agreed. The plaintiff sued and there was a settlement agreement. And 1 year later, they had not paid. So the lawyers came and they agreed that, oh, let the person, the officer, be called to court to come and show cause why he should not be held in contempt. And then later, it rang a bell that no, it cannot be. I cannot say that because the person is not in contempt, but when it comes to government, there is also a further complication in the sense that government's property cannot be sold in execution. I do not know what the statute in Namibia is called, but there's what they call the State Liabilities Act, I think in South Africa. In Swaziland, we call it the Limitation of Proceedings Against the Government Act, all those things. So then it becomes very dicey as to what do you do where government is the one that is owing, but they are not paying. And because you cannot execute against government property. In fact, there is a constitutional case, I cannot remember the name off the top of my head, in South Africa, where the court was split, the Constitutional Court. I think what had happened in that case is that there was a man who was involved in a horrific car accident, and then government admitted liability. I think he eventually died, and it was money for, which went to his estate. I think he eventually died. And then what they did is they went and attached ambulances of a state hospital. And then what the court had to, deal with was, one, compliance with court orders and ensuring that court orders are not given trifling weight. And then on the other hand, they were considering the consequences of attaching state property. Because when you attach, you want to attach where it hurts. If you attach ambulances, then the government will move fast and pay because people might be involved in accidents. But others were saying, no, you cannot attach state property. I can't remember how that case was resolved. But if I recall well, the court came to the conclusion that you cannot attach, property of the government, whatever the circumstance. Because I do not know. As far as I know, the law is, as I have said it, that when it comes to payment of money, you cannot be imprisoned for not complying with a court order in relation to payment of money. Execution processes in that case have to be followed. I thought maybe what you were asking about is in relation to the nature of the case before court. And my answer would have been that whilst the matter is still in the process, even if it's a matter relating to payment of money, you have to wait until judgment for payment has been made before you can deal with issues of execution. But what happened in the Supreme Court? Oh, no. I think here that the difference is that with those others, it is normally at the end of the proceedings. You find that there is a case that is brought for, maybe there's an order that has already been issued to say, do A, B, C, and D. And then, which is at the end of some kind of hearing, and you do not comply with it. That is where maybe you can be taken to court or not. These, I think, are specific orders that have been made to ensure that parties comply with court orders in order to move matters forward towards completion. So if I can call them differently, I can call them intermediate orders. 53. They are designed just to make sure that parties deal with matters and finalize them within or in conjunction, or rather in compliance with Rule 1, Sub-Rule 3. So these are not final orders as such. But with these other matters, it might be that there is an application for you to do A, B, C, and D. And the matter is heard, and at the end of that matter, the court issues what is a final judgment, and you do not comply with it. And I think this is the difference between Rule 53 and the other types of court orders which are issued. Those ones are normally issued at the end of the matter, and a party fails to comply. And then as a sanction for not complying, it will be maybe, there'll be execution if it's monetary. If it is not, it might be, imprisonment or whatever. That will be civil contempt. You can get the difference now. I'm sorry I wasn't getting it, but now I hear and I understand. Is there any question? Do you understand the difference? Yes, I think in Okahao, for instance, the case that I ordered the legal practitioner for the plaintiff to pay cause de bonis proprius, because there is conduct on his part which is incorrect. And what he's going to tell his client is that, the court granted an order for costs against us, so you pay. I even had to put it, cause de bonis proprius, that is to say, from your own pocket. Yes, that was the sanction. There is another matter. It's Transnamib. It's Quinette. Quinette versus Transnamib, I think. Yes. In that case, I think what happened is that the defendant's lawyer was called upon to file a plea, and they did not. And then after some time, they then filed an application for, I think it was for condonation. And the reasons that were advanced were not at all. In fact, they brought an application which was wrong. Because what they had to apply, it was an application for condonation. And then I said, if you are granted an order for condonation, what does it change? Because what had happened is that I think that the claim had been struck or something along those lines. And I say that if you are granted an application for condonation, what does it do? Because there is an order that has already been issued, maybe, I think it was to strike out the defense. So if I grant you condonation, it means nothing. What you need to apply for is rescission of the order that was granted, and you advance reasons for doing so. And then at the end, I asked the lawyer, why should you not personally pay the costs? Because the delay that has been incurred in this case has got nothing to do with the client. And then lawyers take it personally, but we also have a duty towards the clients to ensure that they are not called or they are not mulcted or settled with costs that actually arise as a result of the ineptitude of the legal practitioners. So I think that was the case in Queenette. But then there is another, I will have a list of these judgments. There is another case, it's Donatus versus the Ministry of Health, where what the court said in that judgment was that in dealing with the sanctions regime in Rule 53, the court has to look at many factors and try and balance them out. That you cannot just have a one-size-fits-all sort of sanction. You have to look at all the facts surrounding the matter, and to see, you look at the level of non-compliance, the period of non-compliance, the effect of the non-compliance, and sometimes what I can call there's what they call recidivism, where you are a serial non-complier. Habitual, yes. So if this is not the first non-compliance, you look at the file, you find that there was non-compliance, there was non-compliance there as well. So all these issues have to be weaved in the order, which will fit the circumstances of the case, and also be in line with the overriding principles of judicial case management. So that it's not just to say, once you have not done it, then that's the end of the matter. I had a very interesting case. It's called Meshikwa. Some of these names are very difficult for me. But I think it is Meshikwa. I can't remember Miss Mokomele. If you can just take those cases down, and then I will make them available by Monday. In this case, what happened is that there was a lay person who was sued by another. I think that there was a motor vehicle collision. And then, the matter proceeded in court. The one party was represented by a lawyer. And then I think the defendant acted in person. So what then happened is that the matter proceeded, and then somewhere during the proceedings, I think the lay person filed a counterclaim. And then it then transpired that when they prepared the pretrial order, I'm sure we were aware of what the pretrial order is. That is the report that the parties make, which they want the court to endorse, which will set out issues in dispute, issues not in dispute, factual issues, legal issues to be decided, and so forth. So what had happened is that they had not, in the pretrial report, included the issues to be decided in respect of the counterclaim. Are you with me? So all that they did was for the claim in convention, so to speak. They set out all the issues for the plaintiff's claim, but in preparing the report, they did not deal with the aspect relating to the issues pertaining to the counterclaim. And then the plaintiff's lawyer said, no, Judge, they did not comply. There's no pretrial order in relation to these matters, so I'm applying for the matter to be struck. And I said, no. In terms of the rules of court, the responsibility is on both of you. And you are a lawyer. You cannot now turn around because this man is helpless and then turn and say, no, you did not, because the responsibility was on both of you to do everything. So I'm not going to allow you to have this matter, the counterclaim, dismissed because you now allege that the defendant in the counterclaim did not comply. It was not his sole responsibility. It was the responsibility of both of you. If you were saying, we called a meeting and he refused to cooperate, that would be a different story. One thing that I need to mention is that when you deal with Rule 53, Sub-Rule 2C, dismissing a claim or entering a final judgment, that one must be read in conjunction with Rule 98. That rule reads as follows. If a trial is called and the plaintiff appears and the defendant does not appear in person or by his legal practitioner, the plaintiff may prove his or her claim insofar as the burden of proof lies on him or her, and judgment must be given accordingly insofar as he or she has discharged such burden. But if the claim is for a debt or liquidated demand, no evidence is necessary unless the presiding judge decides or rather otherwise orders. This one speaks about what happens where a trial is called and then one of the parties does not appear. In fact, if the plaintiff does not come, or and then Sub-Rule 2 deals with if the defendant appears and the plaintiff does not. So what I'm trying to say here is that if, for instance, you strike the defense in terms of Rule 53 2C, it depends on the nature of the matter. If it's a claim for, what does the rule say? If it's a claim for a debt or liquidated amount, you can just give judgment there and then. Let's say the plaintiff is claiming 78,000. And then the court has given as a sanction the striking out of the defense and dismissing the claim. Then you can grant that amount. But if some evidence has to be laid, I'm just saying you have to be very careful. Look at the nature of the defense. Or maybe if it's maybe a case of damages, for instance. You cannot then say, merely because the defendant in this case has been sanctioned by the court to dismiss their defense, then the court must necessarily grant the amount that has been claimed. Because evidence has to be laid. For instance, if it's a motor vehicle collision, you have to get an expert to say that the costs that were incurred in bringing the motor vehicle to its pristine conditions were reasonable and necessary. Yes, what I'm saying is that ordinarily, where, let's say there is this defendant who has not filed a plea and has been non-cooperative, and then the court decides that it was going to employ the sanction provided in Rule 53, Sub-Rule 2C, that is to strike out the defense. You must then look at the plaintiff's claim. If the plaintiff's claim is for a liquidated debt or amount, once the defense is struck, the court can readily give judgment in the amount claimed. But if the plaintiff's claim is for damages, then some evidence will have to be laid first before the court grants judgment. You cannot say merely because the defendant has been sanctioned with his or her defense being struck, then the plaintiff is without more entitled to the amount that he or she has claimed, regardless of the fact that it's a claim for damages. No. Rule 98 is different. Rule 98 is a situation where all the case management stages have been followed, a plea is there, witness statements have been filed, everything is there. The case is ready to start, but at the commencement of the trial, the defendant does not turn up. It talks about what happens in that instance. You cannot even call it a judgment by default, because if it is a judgment by default, it means that the the defendant has been served with the summons and either has not filed a notice to defend or having done so has not filed a plea. It is only in those limited circumstances that a judgment by default can be granted. It is not also a summary judgment. Because with summary judgment, that is where a notice to defend is filed. The application for summary judgment has been filed. And normally, the defendant has filed an affidavit resisting summary judgment, but the court is of the view that there is no merit and then grants judgment. So this one is a case where everything is ready to proceed. The plaintiff is there, his or her witnesses are there, ready to testify. The car is idling, so to speak, but then the other one is not there. That is what the court does. But what I was trying to do was to create a link between that rule so that when you face a situation where a party has not complied, a defendant, to say, has not complied with certain court orders, and then the court decides to strike the defense, do not fall into the trap of then granting judgment when in fact it is a claim for damages, because in doing so you will have erred. Which is why I'm then bringing in the provisions of Rule 98. No, there's one case that I dealt with, but it was in the context of case management, where the plaintiff claimed, the claim was based on invoices. But because the matter had not come to trial, where maybe those invoices would have to be handed in as exhibits, I then called upon the plaintiff's legal practitioner to file those invoices so that I could look at them, count them, and ensure that the amount claimed actually has some basis in the invoice or in the invoices that have been filed. I think what we should run away from is a situation where you say, merely because the matter is not defended, I must grant judgment. That is a very, very big mistake. The fact that a matter is undefended does not mean that the court must then willy-nilly grant judgment. I had a case. There's a gentleman, well, maybe I need not even mention his name. But it was a case that came before me on the second motion roll. It was a default judgment. And then the man was representing himself, so he appeared. And then, I found that he had not made out a case. The cause of action was unclear. Everything was just wrong about it. So he gets there. And then, he came and I told him, sir, I'm not going to grant you a default judgment in this matter. I postponed it to a date and I told him the issues that I want addressed, and I said he must come and address the court. So he came, addressed me, and I put questions to him. No, but my lord, the matter is not defended. I said, that's not the end of the matter. The fact that the matter is not defended does not mean that I should grant judgment. I must be satisfied, because the person can come and ask for rescission because the order that I've made is wrong, even though they were not actually in attendance. The fact that a matter is undefended does not mean that the court must, as of necessity, grant the order that is sought. So I then went, and then I delivered a judgment. And then, he spoke and he just looked at me and said, but Judge, the matter was not defended. You should have just given me the money. And then I told him, sir, I've explained myself. So the lesson really is to say, even if a matter is undefended, look at everything carefully. Is a cause of action made out? Are all the necessary allegations that have to be made out? Are there any annexures or other evidence or other documents that are necessary which will assist you in knowing whether the claim has been proved or not? And once you go through that, and one of the most useful books is the one by, what's the name now? I'm forgetting the name. AMLA's. Yes, AMLA's Precedents of Pleadings. That one, you look for any claim or defense, and then it tells you that in any claim, these are the allegations to be made, 1, 2, 3, and 4. So once you do that, you look at a claim, you take the book, and you see that this element has not been met, therefore I cannot grant default judgment, even though the matter is undefended, even though there's been personal service and the defendant has not actually appeared. Okay, are we together? Yes, ma'am. I did not think about this one, but when I just look in a cursory manner at Rule 27, in fact, I think what it does say is that where those defects are merely technical irregularities that do not prejudice the other party or the administration of justice. So I think in terms of Rule 27, it is those, or sometimes you might find that a party has not filed a plea, or they're a day late. Those sort of things which are minor, and as they say, but which do not, prejudice the other party. So where there is a delay, which is serious in nature and effect. But one thing that I must warn you, what the legal practitioners now try to run away from is to filing formal applications for condonation. What they do is to file a status report to say, in this matter, I was hospitalized for 14 days. I was unable to, and my learned friend does not oppose. So, and then they want to make this, or they come in chambers. Hey, my Lord, we are very sorry. My learned friend was involved in a car accident. I'm just making an example. This and this and this happened. I wonder if your Lordship would be amenable to relaxing the... And that then becomes a problem. And then as a judicial officer, you then get torn between not being overly formalistic because you do not want to unnecessarily drag the matter and indulge the parties in paying costs, because otherwise they have to file a formal application which must be on affidavit and may even be opposed. So I think that is where one needs to carefully strike the balance. Once they know that you are a sanctioning judge, they will comply. If you are amenable, they will try to push you to the limit, not to file any condonation application, put it in a status hearing, and ask to see you in chambers. So I think that is the difference between the two sub-rules. But then the other thing is, what matter is it? I will try and get all the judgments that I'm aware of that deal with these matters. But there's one where I drew a distinction between extension of time and condonation, I think. Because there are those times where, and one has to be done before. If you want extension of time, you cannot wait until the time has passed and then you ask the court to extend. How do you extend when the time has passed? So there are all those intricacies that you also need to, to take into account. Let me go back to 53. Then there's Rule 54.1, which says that where a party has failed to comply with a rule, practice, direction, or court order, any sanction for a failure to comply imposed by the rule, practice, direction, or court order has effect and consequences for such failure, and such effect and consequences follow, unless the party in default applies for and is granted relaxation, extension of time, or relief from sanction. Where a rule, practice, direction, or court order requires a party to do something within a specified time or specifies the consequences of a failure to comply, the time for doing the act in question may not be extended by agreement between the parties. I think what this does is to reinforce that it is now the court that is in charge. It is the court that is in the driving seat, no longer the parties. They may agree all they want to, but whatever agreement that they can come to must at least be endorsed by the court. The parties can no longer do things by agreement to say, no, you cannot file or you must file by such and such a day. The court must be in charge of the entire process. So it is to run away from that, that situation, which previously used to exist. And then one of the other things that you must be aware of is that there are some rules which talk about being ipso facto barred. So that there, nothing needs to be done, no one needs to complain. As soon or as long as you have not complied, you are ipso facto barred, which means nothing more needs to be said. From not filing, then you are in default, and probably the consequences of Rule 53 then kick in and apply. Oh yeah, sub-rule 3, 54.3. Where a party fails to deliver a pleading within the time stated in the case plan order, or within any extended time allowed by the managing judge, that party is in default of filing such pleading and is by that very fact barred. So what we must note is that the limit, there is a confined campus for application of being ipso facto barred. What does it refer to? Pleading. So if it's a witness statement, that is different. But if it is a pleading, what is a pleading? Sorry? Yes, replication and so forth, yes. So it is those issues. So it is clear that and I think it makes it incumbent upon legal practitioners to ensure that pleadings are filed in terms of the joint, the case planning order, so that if they do not, they must know that they are ipso facto barred. So that for them to then be allowed, they then have to apply to the court to uplift the bar, to enable them to file the pleadings that they filed or they want to file out of time. And some of the cases actually say you need to attach the pleading to the application. No, what I'm saying is that some of the case law says that to the application for the upliftment of bar, you attach the pleading that you want the court to allow you to file. But then the problem with these issues, and particularly maybe it will come handy when we deal with the rule that relates to condonation. Condonation is a very, very troublesome animal. I say so because not only do you have to explain the reason why you did not file on time, there's also the issue of prospects of success, or, as the case may be, a reasonable, a defense to the claim, if you are the defendant. So you might have a very, very good, plausible, unimpeachable explanation. But if the other leg is amputated, then both of them may well be. But I think there are separate rules from, is it Rule 65 or so, that deal with applications. So this one I would say so advisedly, be confined to action proceedings. Okay. Then Rule 55, the court or the managing judge may, on application, on notice to every party, and on good cause shown. These are very important. On application, that's the first. On notice to every party, that is 2. 3, on good cause shown. make an order extending or shortening a time period prescribed by these rules or by an order of court for the doing of an act or taking of a step in connection with proceedings of any nature whatsoever on such terms as the court or managing judge considers suitable and appropriate. So once we say on application, it means that we then have to comply with the provisions of Rule 65, which means there must be a notice of motion accompanied by an affidavit setting out the grounds upon which, that's the first thing. And this is done so that the other party has an opportunity to know and understand and inform themselves whether or not it is proper it is proper in that particular case to oppose the relief sought or not, which is why it is on affidavit. And then secondly, this must be on notice, which means you cannot have an ex parte application in this case because it affects another party. I think there have been a lot of judgments. There's a lot of jurisprudence that is coming out from the High Court, particularly in relation to poker applications. The Judge Uitele and Judge Angula have written quite a number of judgments that deal with poker and the issues of service, issues of ex parte, because one of the prevailing views had been that in all poker applications are urgent, they are ex parte, and they must be in camera. But the High Court is saying no. Because proceedings being in camera, there's an article in the Constitution which says all proceedings must be in the open. And then the discretion lies with the court on specified grounds why matters should not be in the open. If maybe it deals with, it might be children or issues of state security or whatever other. So the issue of notice is very, very important because it is on that basis that, I mean, we talk about the rule that says the other side must be heard. There's actually a very interesting case that took place in Swaziland, talking about, service or the other side knowing the case. We had I think it was the Industrial Relations Act of 1996. I can't remember, but I think it was. So what it provided for was the government to file an ex parte application where there was a strike which would affect the economy or whatever. So which means that the union or the Federation of Unions would not be served. All they would receive for the first time would be an order preventing them and asking them to show cause why the order should not be made final. So in this particular case, the government filed the ex parte application before the industrial court. And then the lawyer who was representing the Federation of Trade Unions got wind about the application. And then he went to court. He asked for a copy of the application from the AG. Here I think it's the equivalent is the government attorney. There it's the Attorney General. The Attorney General said, no. I'm giving you nothing. You are not party to these proceedings. We've brought them in terms of section so and so. And it's an ex parte. You have nothing to do with it. So the lawyer got a copy from the registrar and then went into court. When the matter started, the judge said, no, I'm not hearing you. This is an ex parte application. You can't be heard. No. So they proceeded and issued the order. So the matter was then taken on review before the High Court. And the High Court agreed that the industrial court was wrong in refusing them to be heard, but then said, looking at how they behaved, there was a court order that was issued. Whether it was right or wrong, they had to comply with it. They couldn't just throw it away and say it was irregularly obtained and then go on with their lives. So the court said because of that behavior, regardless of the fact that they were not heard, that order stood, and it made other findings. And then when the matter went on appeal, the Court of Appeal was very, very scathing on the High Court, saying that, once the party has got wind of the proceedings, you cannot stop him. Even if it happens fortuitously, once he is there, because he has an interest in the order, if you have not been able to prevent him from knowing about the proceedings, once he is before you, he has a right to be heard. You cannot then exclude him on the basis that the application was intended to be ex parte. So I think this is what I'm trying to emphasize in this matter, that it must be on application and it must be on notice to the other side, and then you have to show good cause. I think there's quite a lot of authority that deals with the element of good cause. Good cause normally deals with a reasonable explanation for the delay or whatever. You must present a reasonable and acceptable explanation. And then in all these other issues that come in, deal with the issue of promptitude. If there's been a delay, you have to explain the delay blow by blow. You must not leave any period unexplained. There's a very interesting judgment of the Supreme Court. I think it's Father Pietrus and the Catholic Church. It's the facts that I like more than the law in that case. But it's very interesting. There, I think it was a judgment by, is it Judge Langer? I think it was by Judge Langer, if I'm not mistaken. But this is a court, a judgment that deals very, very well with the issue of condonation. It deals well with the issue of condonation, what does good cause entail, and then also the element of having, rather showing that you have good prospects of success. Because I think in that case it was a matter involving the church, and the question that arose was whether the court should have jurisdiction over matters relating to the church. And the court said this case is a hybrid sort of case. There are some issues that pertain solely to the church, but there are also other matters, I think issues of eviction, which, if I remember correctly, that are not necessarily what you can call ecumenical issues. So these are the issues. So when you have an application for condonation before you, you have to look at it very carefully. There's one that I granted not long ago, although it was on PD 61. When I started dealing with the case, not that my mind was made up, but I had a prima facie view, and not a weak one for that matter. And it was not unjustified, even if I say so myself. It was based on, there's a case that I referred to, the one of I.A. Bell, which I will give you the particulars of. The one where I said the lawyer took about 3 months. In this one, I think it was the same thing. It was a lawyer in government. I think she took more than 3 months to file the plea. And the explanation that she gave is that she had too much work. And then she also said her grandmother died, So when I looked at it, I found it was on all fours with I.A. Bell. But when they then started arguing the matter, what became apparent is that this young lady's grandmother was sick over a period of time. And she took leave during certain specified periods within the time of non-compliance. And there were leave forms that had been signed showing that she was away. And the grandmother eventually died within the same period, and a death certificate was filed. So I had to look at the matter from that perspective. Okay, she was inundated with work, that is one aspect. But here is a relative who is sick, and I think she had to travel to Katima Mulilo, which is a long distance. And then my prima facie view was shattered, and I granted condonation. Particularly because I was impressed with the fact that there was a blow-by-blow account of the period of the non-compliance. Because what lawyers will do in explaining is just to make one simple statement, which does not fully account of the entire period. And then courts must be very, very strict in dealing with these applications so that parties know that once you do not comply with a court order, there is no reverse. This train has no reverse gear. It's like a motorcycle. It goes forward only. So once the court takes a step of implanting in the minds of the legal practitioners and litigants that court orders matter, and that non-compliance with court orders has grave consequences, which might even see you being shown the door of the court, people are going to take court orders seriously and court rules and practice directives. But once the court becomes lax, becomes understanding, and says, no, but people must be allowed to have their case heard, then decadence is going to set in, and judicial case management will be a mere shibboleth and only a pipe dream. No, I'm saying that it might have been that the court took the view that it was probably something not very serious. I do not know. But then sometimes also, I mean, you get the human element of being sensitive. Because, I mean, I think there were cases where there's one lawyer who passed on a few weeks ago. I think he was diagnosed with cancer or whatever. And then there were cases that arose in relation to him, which related also to his, to his sickness. And sometimes you also find that with those types of matters, to then indulge, because for an application to be done, you might find that it is the client who has to pay. And so sometimes you say, I understand the reasons, but condonation is granted, which might be fine in some circumstances. But what I'm saying is that the court must look out for not creating that as a precedent, because legal practitioners are not going to comply, knowing that the court will not call upon them to file affidavits, and then they will just get away easily with it. Well, lawyers are normally sensitive people, particularly when it comes to issues such as that. It would be maybe a bit odious for you to insist when there's been a misfortune such as death or maybe sickness even, on the part of a colleague, to say that, we understand that, we hear that, we sympathize with you, but our client is still entitled to costs. I think lawyers will normally tell their clients that, hey, this can happen to us. I can be in such a situation. So I would think it is not an appropriate case to deal with. But I think if such an application comes, the rule is that costs are in the discretion of the court. But then in exercising that discretion, there are certain issues that the court will take into account. So it would be very difficult to lay a basis, rather to say that this is what the court would do. A lot would depend on the circumstances. But it might well be that if there is some element of remissness on the part of maybe the lawyer who has maybe passed on, the court might well be, justified, at least in granting costs in certain aspects, if not the whole case. I think there's one judgment. I'm sorry that for me, it's always convenient to speak about cases that I do, not because I think I am correct or anything, but it makes it easier to explain them. So do not think that, he's busy telling us about these cases. promoting, vivaring his cases. Not at all. Not at all. But what happened in this case is that there was a motor vehicle collision. A's car is I think it was parked. And then there's a car that collided with it, ran away, didn't see whose car it was. But they saw the registration number. And then they immediately then issued summons against the register because they went to NATIS to find out who was the registered owner. Then they sued this man. This man says, no, this is not my car anymore. I sold it to C 5 years ago. The only thing is that that vehicle has not been changed into C's name. And then A then issues a third-party notice to bring C into the proceedings. And then once C is part of the proceedings, then they decide, let us let B go. You understand? Yes. Yes. And so the matter then proceeds, and then B says, I want my costs. From the beginning, once you knew that the car did not belong to me, I'm going to apply for costs on the ordinary scale. But from the day that you persisted until you filed the third-party plea, I'm asking for costs on the attorney and client scale because there was really no reason for you to hold me in terrorem, so to speak, in the proceedings because you knew you had been to NATIS, you knew who was the owner. Why did you keep me enyoke, so to speak, in this matter when you knew that I had nothing to do with the case? And then the issue that I think loomed large was who is to issue a third-party notice? Is it proper for the plaintiff to issue a third-party notice? Because the plaintiff has a lease with the defendant. And the one who's supposed to bring the third party is the defendant. And the view that the court took was that in this matter, as soon as it became clear that the car belonged to C, what the plaintiff had to do was to withdraw its claim and tender costs, and then pursue C in separate proceedings altogether. So I granted the costs, staggered, ordinary scale, from B, this stage to that stage, attorney and client, yes. I might be wrong, but that's how I saw it. That's how I saw it. So I hope I've answered your question, ma'am. Thank you. Maybe it's an appropriate time for us to adjourn. Until? Sorry? 2. Okay. I won't be very long after lunch.